Welcome. There are many out there who post slogans such as Free Bryan or Free Kohberger, and I always think, what if he's guilty? Do people stop and think that he, like many in this story, may be guilty of murder? So, to be fair to the process that will begin with this first module of Unlawful, and think about answering the following question. Is Bryan Christopher Kohberger guilty? Or is he not guilty? This is the sign above the proverbial door. This is the first step we must take together in helping somebody who may be either guilty of crimes accused of committing, or else not guilty and therefore shouldn't be living in prison for crimes that he has nothing to do with. There is power in numbers. So, when you have a minute, let me know what you think about the initial question and include the reasoning behind your answer. You don't have to make it complicated. Is he guilty or not guilty? And then briefly state your reasoning or rationale. Let's get on with Module 1 of Unlawful. I thank you.
So today, you are all, I think, listening in, either in person or with the live stream. We have reached the conclusion of the judicial process, and we believe we've achieved accountability and finality and certainty for everyone who has suffered from this, so we can try to move on.
So according to Prosecutor Bill Thompson, he believes that they have achieved finality and certainty. Please lend your attention. Factual guilt lies in whether the accused actually committed the act, while legal guilt lies in whether the prosecution has proven every element of each charge or charges beyond a reasonable doubt. It's easy to gloss over these terms and take the spirit of them for granted. The question that I have for you is a question of proof versus causation. Proof versus causation. Question: what proof exists that shows us that any action or actions of Bryan Kohberger caused the death of Xana Kernodle? What proof exists that shows us that any physical or mechanical action or actions of Bryan Kohberger caused the death of Madison Mogen, Ethan Chapin, or Kaylee Goncalves? In murder trials, the prosecution must prove both factual causation and legal causation to secure a conviction. The absence of factual causation immediately defeats the murder charge because it means the defendant's actions did not cause the death, resulting in acquittal for that specific crime. Factual causation establishes a physical or mechanical link between the defendant's action and the victim's death. There is zero evidence proving any possibility that Bryan Kohberger caused the deaths of those killed on King Road, especially while 2 or more associates of theirs were present in the home and awake during the times they were murdered.
And also, how do you as investigators and attorneys grapple with that? Because if you can't rationalize something irrational, then how do you continue knowing that maybe you won't get an answer?
Well, I'll tell you from an investigator standpoint, we already know and realize we often don't get to know that. We want it. We all do. We naturally want that. But the reality is it's not something that we have to have or that we get. And the reality also is that oftentimes those very things that you're asking about, they're only known to one person. It's the person that commits those crimes. And I think that's probably what we have here.
And I would add that going through this whole investigation, I'd probably say it's easier than it was for Bill's offices. We were focused on a task. We had a task to do, and it was discovering evidence and interviewing folks and that sort of thing. So the motive necessarily doesn't play a part in that, right? Obviously it can, but we were just focused on getting the job done in the correct way as best we could. So,
And from the prosecutor's point of view, yeah, certainly lack of a clear motive is something that we think about and consider as we're preparing for trial, because we're going to have a jury of 12, ordinary, honest citizens there who are wanting to figure this thing out. But we also, and I've also found that juries tend to follow the law. And even jurors who come in with strong feelings, they tend to follow the law that the judge gives. And there is no element of motive in Idaho law for murder. And so we set that aside as something that we were going to dwell on, whether there was clear proof of a specific motive, because we knew it wasn't legally required. And practically speaking, we knew it wasn't something that we possessed that we could give to the jury without speculating. And I'm sure as heck not going to stand in front of a bunch of 12 jurors and start speculating. We're going to give them the evidence. And the evidence in this case, what you heard at the time of his guilty plea back on the 2nd, that evidence was compelling, and it showed his guilt without having to worry about motive in a human sense. But thank you for the question.
Determining criminal guilt requires the person to separate factual guilt, whether the accused committed the actual act, from legal guilt, whether the prosecution has proven every element of the charge beyond a reasonable doubt. We have the burden of proof versus the presumption of innocence beyond a reasonable doubt. As we have seen in the case of Idaho versus Kohberger, he was without the presumption of innocence from day one, and they had their arrest with only 10 days to go before the start of spring semester at the University of Idaho, Moscow campus. In any case, under the legal framework of the United States judicial system, the prosecution carries the burden of proof, which requires a standard of beyond a reasonable doubt. This is what is required at trial. The prosecutor must prove guilt beyond a reasonable doubt with each and every item of discovery.
Over here.
Did you monitor Mr. Kohberger's communications while he was incarcerated? And did he say anything that was helpful or gave you any insight as to why he did this?
Yeah, we did monitor it, both while he was housed in Latah County and then once he was moved down to Ada County. We have hundreds, thousands of hours of monitoring that was done, but there was nothing of evidentiary value that was gained from any of it.
Detective Gilbertson's honesty is much appreciated. Evidence must be so strong that no logical explanation other than guilt can be drawn. Let's take a look at each pillar of the state's case against Kohberger. Which one of these is and was strongest proving Kohberger guilty of the 4 murders? Which was the weakest, in your opinion?
Is it possible that there was a second murder weapon used, not just the knife?
Is it possible? All the evidence shows and tells us that he used a knife, a K-bar knife, and that's the weapon we believe was used to commit all the murders.
The defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the 3rd floor, and with a knife, killed Madison, Mogen, and Kaylee Goncalves. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But
Here?
It sounded like the Goncalves family said that there was a second weapon that was used on Kaylee Goncalves. Can you confirm that?
Out of respect for the families, that's something that you'll have to get from them. If they wish to share that with you, it'd probably be through them, not through us.
I'm curious as to where you think or believe the murder weapon is, where you think or believe clothes Kohberger was wearing that night are, and how do you think he avoided forensics?
Well, I can just tell you, and forgive us if we go back and forth, it's just kind of how we roll. But there is no evidence that we found that would lead us to any specific, even general location as to where the murder weapon or the clothes have been. And we searched. I mean, the FBI, again, to their credit, we had folks doing soil samples and so all sorts of things to try to come up with somewhere to start searching for these things, and we just never found it. As far as the forensics piece, I'll let Darren speak to
Yeah,
that.
and on the weapon, it wasn't a lack of trying. Everywhere that we had evidence of where he went, based upon phone records, based upon the evidence that we had gathered, we searched that. We went there. We did searches on the ground, in the water. We did searches. We sent soil samples to try to figure out maybe where a shovel had been used. So we searched everywhere that we possibly could, but the reality is we're looking for a singular small, it's not that small, but a K-bar knife, and that's it. So it's endless of where it could have been, and we just were not able to find it.
What
So
about the clothes and his ability to go to avoid forensics at the scene, in a murder scene where we now know Kaylee Goncalves was stabbed 34 times and then another victim was stabbed more than.
right. So the reality is that somebody can carry this out and still not get covered in blood. That's the reality of it, and this does happen, and there's plenty of studies of that. And we've had some of the world's experts that we've asked those same questions, because we've struggled with that. Why do we not find more here and there? And the reality was, if somebody has the training, if somebody has thought about it, if somebody wears the right type of clothing, that could be the outcome, and that's what we were left with. Over here.
It was never about Bryan's innocence, but rather, he needed to be found not guilty by a jury of his peers. Think of Bryan Kohberger, the human being, the person. Where in Idaho would you be able to find a jury of his peers to give him a fair trial?
Look at this, Cleveland. Front of the bus, back of the bus, middle of the bus. You guys are doing great.
I can't believe this. 2 weeks in prison on trumped-up charges. That trial was a total sham.
Yeah, I knew we were in trouble the minute I saw the jury. Well, at least they're a jury of our peers.
I don't think they see it that way, Peter.
Courts strictly determine legal guilt, not absolute innocence. A not guilty verdict simply means that the prosecution failed to meet the required burden, and not necessarily that the defendant did not commit the act or acts that they were charged with. The influence of human factors and bias, and their effect on evidentiary reliability. First, what is evidentiary reliability? Evidentiary reliability refers to the trustworthiness and accuracy of evidence. It determines whether facts, documents, or testimonies are sound enough to be admitted in court. To ensure a fair trial, judges evaluate whether evidence is logically relevant, scientifically sound, and free from significant bias or tampering. Is there any piece of evidence in the case against Kohberger that you believe to be unreliable? What might that be? Feel free to share. We know what biases are, which may or may hinder the reliability of evidence. But what are some of the human factors, so to speak, that may also have an effect on the reliability of evidence presented by either state or defense? In Idaho versus Kohberger, according to the Institute for Creation Research, the focus of the federal rules of evidence is evidentiary reliability. Why? Because just laws need reliable evidence, whether that evidence is forensic evidence, empirical evidence, or a combination of both. The fundamental issue is, or at least should be, recognizing truth. Human factors significantly degrade evidentiary reliability by distorting how individuals observe, recall, and interpret events, or how they generate and record data. These limitations, ranging from cognitive biases to physiological stress, introduce error into eyewitness testimony, forensic analysis, and standard record keeping. Can you think of any evidentiary item from either the state or Kohberger's defense that may have fallen into any of the above said categories? propaganda replaces evidence when emotional appeal and strategic repetition override rational facts. By using assertion and selective information, it exploits cognitive biases to make false narratives feel true, insulating beliefs against counter-evidence. Propaganda began to replace the need for evidence from day one, when Latah County Prosecutor Bill Thompson said this to the public.
Once he gets here, he'll have an initial appearance with our magistrate. They'll deal with issues such as making sure competent counsel is representing him, and the case will be scheduled for further hearings. Your primary source of factual information is going to be the court record, because that's what the Supreme Court says we need to refer you to. So please pay attention to what's going on in court and have people there to watch and hear what's being said. As an attorney, myself and my office, we are limited on what we are allowed by the courts to say outside of the courtroom. So please just work with us. Finally, as the chief indicated, this is not the end of this investigation. In fact, this is a new beginning. Y'all now know the name of the person who has been charged with these offenses. Please get that information out there. Please ask the public, anyone who knows about this individual, to come forward, call the tip line, report anything you know about him to help the investigators and eventually our office and the court system understand fully everything there is to know about not only the individual, but what happened and why.
Yeah, so we're our safest city in America.
Telling her, just when campus was getting some momentum, and enrollment was up, and people were excited.
$1 million to go to help fund the investigation into the death of the students at the University of Idaho. I'm wondering where your caucus stands on that commitment and if more money potentially could be coming if a solution in this investigation doesn't come soon.
Oh, I mean, I absolutely support investing the resources needed to get to the bottom and finding the killer, or I hope not killers. I'm assuming single killer, but we really don't know. I mean, just, life and safety is so fundamental to our state. In this case, I think actually it's going to be a snowballing disaster if they don't get to the bottom of it. I'm really concerned that we're going to see dropping enrollment at U of I. My daughter's best friend is there. I know folks who are there who do not want to go back. They don't want to go back for, I think they're going to see collapsing enrollment. They're going to see people transferring out. Nobody wants to send their kid to a community where they could face this kind of horror. It is every parent's worst nightmare. It's every student's worst nightmare. They have got to find the perpetrator. And I think $1 million is a bargain if it gets us to the bottom of this. And I would support investing more than that if that's what it takes. Because again, I fear the likelihood of the University of Idaho and the safety of everybody in that community is on the line. We have got to get to the bottom of that case.
With that, we will leave it there. Minority Leader, I appreciate you being here with us, and I hope you'll check in with us a couple more times throughout the session. I know it's not begun just yet, but busy time for you coming up here soon, and we appreciate you joining us from Washington, D.C. this morning.
Thank you so much. You call me anytime.
Will do.
Always great to talk to you.
Thank you.
Now, that is motive for a cover-up if we're ever going to see one. When propaganda becomes increasingly hyper-aggressive, it is often a sign of desperation, attempting to mask a larger scandal. This pattern of manipulation relies on coordinated messaging, sensationalism, and manufactured controversies to distract the public. Dominating public attention steers the narrative away from core issues at play. The goal of this manipulation is usually to hide incompetence, corruption, or scandalous events using emotional manipulation. What took place at 2:35 that morning? Keep that time in mind. 2:35 a.m.
It was stated earlier that the target is unknown. However, it's been speculated that the convicted may have encountered Maddie while she was serving at the Maddie restaurant due to the vegan menu options. When his digital data was analyzed, were there any location pins or any information there that could have connected him to where Maddie worked?
No, there wasn't. And like I said earlier, we wanted that. We looked for it in every possible way, digitally, financially, physical location, anything you could think of, anything that we thought, where is the connection? Where's the overlap? And we searched tirelessly and never found it.
Was at that restaurant.
I can't say that he was never there at all, but we never found any evidence at all from interviewing everybody that we possibly could, talking to every person that would have that information to be able to show that he was there or that there was a connection through the restaurant.
Just wondering if you ever had any idea of what made Mr. Kohberger take the plea deal in the end?
No.
Okay. Can I ask a follow-up question? I know there were reports.
That was a short answer. You probably have time for a short follow-up.
Can I also ask a follow-up to the investigators? I know there were some reports that there was Kohberger was hiding some container out of the house. Did you ever determine what that was?
No, and the belief was in the one of the surviving roommates in her statement, and that's out there, was that she observed something in his hand when she saw him, but we don't know what it was.
Potential jurors, lead investigators, and even prosecutors may determine validity or value of evidentiary items due to psychological biases that cause these critical decision makers to unconsciously filter information so that it lines up with their pre-existing beliefs or expectations. This can lead to the overvaluation of supportive data, while contradictory, or more importantly, exculpatory evidence is ignored, minimized, or intentionally misconstrued.
Here.
Thank you. Greg Fisher with CBS News 48 Hours. Was there any evidence that Kohberger was following the social media of any of the victims?
So, trust us, we wanted that to be the case. We've looked for a link, and we have not found one. Not one.
Yeah, through the entire investigation, I think that's something that we need, that you want, is to help to understand this and say, well, what's the connection? What was the link? And so we had every resource possible, and we worked that tirelessly, both from everything from his side, but all the victims and all the members of the House from their side. So we have never, to this date, found a single connection between him and any of the 4 victims or the 2 surviving roommates.
Approximately 95% of felony convictions result from guilty pleas rather than trials. Innocent individuals often plead guilty to avoid the extreme risk of harsher penalties if a jury were to convict them. What would you do if you were in Bryan Kohberger's place, assuming you were innocent of the crimes you were being accused for having committed? Think about that. Next, Kaylee Goncalves' father, Steve, leaks something that, well, take it with a grain of salt, let's just say at this point. But here, Steve claims that Bryan Kohberger preferred an offered plea rather than a straight-out plea agreement. What this tells me is that Bryan wanted to go to trial, and for some reason it was in his best interests to sign the plea agreement. Why would Bryan Kohberger, very determined to roll the dice at a jury trial in Ada County, all of a sudden decide to make a deal with Bill Thompson if he was innocent of the charges against him? No Alford plea mixed with no allocution. Something's afoot.
But, ultimately the truth comes out. And, for people to say, oh, he didn't do it. Like, he pled guilty.
4 times.
4 times, plus the burglary. People don't plead guilty to consecutive life sentences unless they did it.
Yeah, there's these fringe cases where people plead to something that they didn't do, but they're not for. It's like a one-off, and they're like, I can't defend myself. I was a druggie. I have all these other
I need to get out of jail. They're offering me a misdemeanor. Fine, I'll take it. I get that. We're not talking about a speeding ticket, though, where you're speeding and they give you a defective headlamp, right? We're talking murder where you're going to spend the rest of your life in prison.
An Alford plea. They wanted to do an Alford plea, and we were like, I rallied everyone and said, we ain't doing this.
In the 1970 case, North Carolina versus Alford, the Alford plea was born, affirmed by the United States Supreme Court, which would, from that time forward, allow defendants the possibility of accepting a plea deal to avoid more severe consequences, such as the death penalty, even while asserting their innocence. One of the perks to accepting an Alford plea would be that those truly innocent or guilty of the charges made against them could maintain their innocence while never admitting their guilt. Think of the person who is truly guilty as charged who doesn't want to admit their guilt publicly. And now, think of a person who is truly innocent of the charges made against them, not wanting to admit guilt. To the former, why should anyone be made to do anything? And to the latter, why would anyone who is truly not guilty say that they are in fact guilty? Well, for the same reason why innocent human beings, accused of having committed a crime, accept plea deals to salvage their lives. There are some cases where a defendant wants to maintain their innocence, while acknowledging that the state has enough evidence to convict them at trial. Remember, evidence alone does not convict, nor does a jury, but some judges in some regions are very much connected and are selected for a reason. They are not disqualified from the beginning with a show of good cause. Everything is truly connected. More on that later, tomorrow, but definitely not never.
Judge Hipler talked today about the fallacy of expecting that there would be some miraculous coming clean and disclosure from the defendant. In the first instance, as the judge said, he doesn't have the power to compel that. We, the state, don't have the power to compel that. And as a practical matter, it would not be helpful. It would give him a forum to share whatever he thought to control the dialogue. Not going to happen to our victims. We can't allow that to happen.
What could Bryan Kohberger possibly say? They who own it say the most about it. and he is right in addressing the forced lane as our victims there. It was your state. It was your county. It was your municipality. It was your educational institution. It was your house. It was your people. This was your choice. It is your own. You own it. And as went the house, so went your victims.
Chief?
I guess my question is for Mr. Thompson, since you're still up there, Internet Lady with Law and Crime. You said that, it was your decision to accept this plea agreement. It brings finality, people die in prison, but Corporal Payne just said they don't know who the target was and why he targeted this house. Was there a reason why, as part of the plea agreement, you didn't require Ann Taylor to have her client sit down with you all and to answer some of these questions?
I think that Judge Hippler addressed that today very, very well. Of course, Judge Hippler addresses everything very well, we've found. The law does not give the court or us the power to require a specific factual allocution. And just let me finish. And we recognize that. We recognize that we could have said, well, in order for us to move forward, we want a factual allocution. But I have to be perfectly candid. I don't believe that there's anything that would come out of his mouth that would be the truth. I don't believe that there's anything that would come out of his mouth that would be anything other than self-serving. And I don't believe there's anything that would come out of his mouth that would not further victimize the families. And so that just simply wasn't a factor. We made our decision based on our assessment of law and the facts. We made our decision based on being able to obtain accountability and certainty, not just for the victims' families, but for the communities and for the state. And that's where our obligations go. In the end, and the old Harry Truman thing, the buck stops on my desk. Well, that's what I got when I was elected prosecutor 33 years ago. I never dreamed it would involve something like this, but we don't shirk our responsibilities just because it got big and nasty.
By submitting an offered plea, a defendant is treated as guilty by the court and receives the corresponding penalties, even though they never say, "I committed the crime." I want to wrap this up by recalling something that Bryan Kohberger said back when he was first taken into custody the 30th day of December, almost 4 years ago.
Gotcha. So you're essentially just as much in the dark as the rest of us when it comes to any connection he might have had to these students or a possible motive if he did commit the crime.
Correct. I wanted to view the case objectively myself also. So I was working in the blind because I didn't have the affidavit of probable cause. So I wouldn't even be able to discuss anything with him, even if he relayed any information to me.
Gotcha. So you said before that he helped you craft the statement that you made on his behalf after his arrest. What was his opinion on the statement? What did he want to make sure was said or was included?
I think the most important part was the exoneration part. He believed that he would be exonerated, which to me implicitly meant that he was innocent of the crimes, so that obviously there wouldn't be either enough evidence or he was going to be found innocent of the crimes.
Bryan, you have just spoken with that public defender who represented Kohberger immediately after his arrest. What have you learned?
Yeah, this was interesting, actually, because last time we saw the public defender in Pennsylvania, Jason Labar, he was with Kohberger in court. I was in the courtroom, but he had not seen the 18-page probable cause. So now he has. I asked him what he thought about it, and he says he thinks there are holes in the probable cause. He is questioning the phone pings. He says that those pings are not specific GPS coordinates, and he says the defense can have a
With the news of suspected killer Bryan Kohberger's recent grand jury indictment, Monroe County Public Defender Jason Labar says he doesn't think it changes anything for his former client, who said he was eager to get back to Idaho to be exonerated.
This indictment is really just the formal charging instrument against Bryan.
It's just formalizing the allegations. Idaho will still have to prove him guilty beyond a reasonable doubt. So I think his stance would remain the same.
Skipping a preliminary hearing in a case like this can hinder a defense, according to Labar, but it also works in its favor by not allowing any information to be released that could influence potential jurors.
Bryan said that he expected to be exonerated. He didn't say that he expected to be acquitted. Let's look at some meanings. To acquit means to release or discharge a person from an obligation, burden, or accusation. In criminal law, it is the formal judgment of not guilty entered at the end of a trial when a jury or a judge in a bench trial finds that the prosecution has not proven the defendant's guilt beyond a reasonable doubt. An exoneration occurs when a person who has been convicted of a crime is officially cleared based on new evidence of innocence. Don't worry yourself with the thought that a defendant need not prove his or her innocence. I'm just sharing only one of a multi-prismed hope for innocent convicts. An exoneration such as this may occur due to a pardon based on actual innocence, a vacated conviction, and/or a dismissed indictment. An exoneration may also occur during an acquittal at retrial, but then Bryan never received such a thing, the right to trial. But he did say that he expected to be exonerated. Now, a DNA exoneration is when a person who has been convicted of a crime is officially cleared, based on post-conviction DNA testing. Keep this in mind. One example of post-conviction DNA testing can occur when DNA testing results were clearly indicative of the defendant's innocence and plays a central role in vacating or wiping out the conviction, or else enabling the dismissal of an indictment. Post-conviction DNA testing is a legal mechanism that allows convicted individuals the opportunity to test or retest biological evidence. Listen up. Using advanced forensic techniques, you just need a good guy at the controls. Its primary goal is to establish actual innocence, but it also allows you to identify true perpetrators or rectify wrongful convictions in serious felony cases. Post-conviction DNA testing may also be used in the examination of biological evidence from a criminal case that is considered closed. Its primary use is to exonerate wrongfully convicted individuals, or like said, identify true perpetrators. Isn't it strange that the Innocence Project of Idaho suspended its services in April of 2023 due to lack of funding, just 1 month before Bryan was indicted and officially charged? The truth always comes out in the wash. It may be useful to note the following information. The Bureau of Justice Assistance is out of the Office of Justice Programs, which comes to you by the U.S. Department of Justice. The fact sheet I am referring to was published in November 2024. The Post-Conviction Testing of DNA Evidence Program funds projects that assist states and units of local government with post-conviction DNA testing in cases of violent felony offenses where actual innocence might be demonstrated. Again, don't be put off by that which sounds like a requirement for the convicted person to prove their innocence. You have to begin somewhere, right? This is one block of information. Anyway, the Department of Justice's mission is to ensure fair and impartial administration of justice for all Americans. I want to trust these words I would even go as far as to believe that all people within the United States have constitutional rights out of our respect for human rights worldwide, but that doesn't mean that everyone thinks this way. While successful exonerations to correct injustice are notable program outcomes, the careful review, consideration, and closing of cases subjected to post-conviction DNA testing that do not ultimately demonstrate innocence also work to advance the public's interest that justice has been fairly applied. Innocence has an opportunity to be demonstrated, and this does not happen without help from the outside. Inside, hope dwindles, even while the inmate assimilates to his or her new environment. There are two categories of this program's goals. The Bureau of Justice Assistance's Post-Conviction Testing of DNA Evidence Program aims to assist in identifying potential post-conviction DNA testing cases. There must be researchable criteria that would indicate whether Kohberger's case even qualifies for the program. Could DNA testing prove his innocence? Well, the program also assists with locating biological evidence associated with such post-conviction cases. Were there any other bodily fluids or DNA samples collected from each of those crime scenes? The final consideration within Category 1 is performing DNA analysis of appropriate biological evidence and reporting and reviewing the DNA test results. We would have to do further research to learn what the Bureau means by the word appropriate when addressing the types of biological samples considered as evidence. The formality of language used in these types of well-meaning programs, or else guides to best practices, as we have seen with the mishandling and premature reliance on forensic investigative genetic genealogy in the Kohberger case, is just that, formality in language used in publications such as the one we are skimming here. Nonetheless, it's an honest idea, wanting to find out exactly whose DNA was collected from the King Road house, beginning with each of the decedents, and then working outward, circumferentially. If you read the summarized accounts where exonerees were initially convicted, you can find this under the section entitled Recent Exonerations. You'll see how DNA collected linked to another suspect who was later arrested, as was the case where Martin Santillan was initially convicted. And in the case of Albert Schweitzer, a Hawaii case, Schweitzer and other convicted defendants were eliminated as contributors to samples taken in that criminal investigation were eliminated, and another unknown male was later identified. It's difficult to think that DNA could both convict someone and also exonerate them, but we would have to look deeper within each of these unique cases to better understand why this could possibly happen.
Did he say anything when he was arrested?
Yeah, so Brett, myself, and members of the FBI, we traveled back to Pennsylvania. We were there, and I know they hit on it earlier, but I'd be remiss without talking about the cooperation and the support that we had from them was absolutely incredible. From the time that we got on the ground with the Pennsylvania State Police and with the FBI back there, it was unbelievable. Anything that we needed, they were there to facilitate it. So we helped to shape what that looked like, what the arrest looked like, what took place once they hit the house on the search warrant and he was taken into custody. Brett and I were at another location, a barracks of the Pennsylvania State Police, and then he was brought to us and we conducted an interview with him that night there in Pennsylvania.
Can you talk about what he said?
So we went into this interview, we used a lot of influence and guidance from the FBI and their behavioral analysis unit. They helped us a ton in framing our our interview strategy rather. When we spoke to Mr. Kohberger, we kept it pretty surface level to begin with, the idea being get him to speak and keep him speaking. It was pretty surface level, and then when we tried to get into things a bit more detail, he decided to end the interview. So that's pretty much
as soon as we tried to walk into the purpose of why we're there, which obviously he knows we're detectives from Idaho, so that's when we really started to shut down, and then he just shut it down. So
what was his demeanor?
Calm, relaxed.
Say very similar to what you see and whenever you see him in court.
Next question.
With all of this talk lately, from people who were associates or friends with the 1122 King Road residents, we have learned how the house was often the place to go for any reason, at any time of day or night, even to sleep there if needed. Some of these people who have stayed at the house are much older than the residents themselves, both male and female. So, a regular open back slider door, according to the documents and interviews, leads me to ask a question of reason in reference to the burglary charge. If Bryan Kohberger was in the house, how would one know if he had not been invited by one or more of the residents? We can't ask Xana and Ethan, can we? According to Dylan, she had never seen Kohberger before after Bryan was arrested, so he couldn't have been invited in by Dylan to help her clean up the crime scene. How are we proving Bryan's entry at all? Whoever was in the light-colored vehicle that we see, driving around the neighborhood, night, into early morning, how can I prove that the vehicle's occupant or occupants even pulled into the court behind the 1122 address, let alone actually entered the King Road residence? We can't.